everyone, welcome back to the channel. My name is Varun Kaushal and I'm a legal intern at LEXIS and Company. Today we are going to discuss about the topic daughter-in-law's right of residence under Domestic Violence Act in-house. The Honorable Supreme Court has in its judgment in Satish Chandra Ahuja vs. Sneha Ahuja Civil Appeal number 2483 by 2020 has held that the rights of the woman in capacity of daughter-in-law for residence order in the property exclusively owned by her father-in-law subject to the house being a shared household in which the daughter-in-law has lived in a domestic relationship with the father-in-law. What is a shared household? The term has been defined under Section 2S of Protection of Women from Domestic Violence Act 2005. The right of residence provided under the Act to women ousted from the house or prevented entry thereon has been envisaged qua shared household only. It is therefore safe to state, as per the Act, a shared household would mean a house in which the aggrieved person has lived or at any stage has lived along with the respondent in a domestic relationship, that is, a relationship between two members who have lived together on account of being related by consanguinity, that means by blood, marriage, or through a relationship in the nature of marriage, adoption, or are family members. The Supreme Court, by the above captioned judgment, has categorically overruled its earlier views observed in S.R. Batra vs. Taruna Batra 2007, being wrong interpretation of Section 2S of the Act. In the said case, the Honorable Supreme Court held that a wife is entitled only to claim a right to residence in a shared household under Section 17(1) of the Act, which would only mean the house belonging to or taken on rent by the husband, or the house which belongs to the joint family of which the husband is a member. The implication of this observation was that the mere factum of the spouses to have lived in the house exclusively owned by the husband's father as a gratuitous license, the property would not become shared household for the purposes of the Act. The Honorable Supreme Court observed that the definition of shared household in the Act is exhaustive in nature and would cover only those households which are envisages under Section 2S of the Act. The Honorable Supreme Court, after detailed analysis of the said term, summarized that it is not a requirement of law that the aggrieved person may either own the premises jointly or singly, or by tenanting it jointly or singly. The household may belong to a joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has nay right, title, or interest in the shared household. The shared household may either be owned or tenanted by the respondent singly or jointly. Therefore, the respondent certainly would succeed in obtaining residence order in the dwelling place exclusively owned by the father-in-law, and this authority would act as binding precedents, and this question remains no longer res integra. However, a legal complexity which would arise is that if the shared household is not required to be owned or tenanted by the husband or belong to a joint family in which the husband has a share, it would encompass within itself all the dwelling places the couple has resided in a domestic relationship in several years, and would also include dwelling places of relative where the couple might have resided, as in many occasions is witnessed. Thus, it was only imperative to interpret the phrase "the person aggrieved lives or at any stage has lived" as appearing in Section 2S of the Act was correctly interpreted in Satish Chandra Ahuja vs. Sneha Ahuja in alignment with the legislative intent, which limits the shared household in context of the Act to mean the dwelling house of the aggrieved person in the present time, or the dwelling place where she resided with the respondent immediately before approaching court. The judgment cleared that shared household would not mean each and every dwelling place the aggrieved person resided with the respondent in a domestic relationship, as it would lead to chaos in the society. In conclusion, the judgment has rather now opened a Pandora box which would now be relied upon the litigants seeking residence order under the Act in the dwelling place even when the same is not owned. rented by the husband, or belongs to joint family of which the husband is member of without having share in the same. In my personal opinion, this can be taken as a welcome step as it has the effect of addressing the lacunae in the definition, act as a tool to reject residence protection under the act under the grab that the dwelling place is owned by the father-in-law and mother-in-law, as the case may be, in which the husband has no share. However, the Honorable Supreme Court has also laid stress that father-in-law or mother-in-law, usually at the age of senior citizens, have the right to live peacefully and not haunted by the marital discord between their son and daughter-in-law. Therefore, the court is duty-bound to balance the rights of the parties while deciding such applications. That's it for today's video. Thank you for watching. Please don't forget to share, like and subscribe our channel LEXCLIQ.